Well, hello, everybody. It is time for Zoom Landlord-Tenant Talk Radio. It's another edition here every Saturday at 3 p.m. I am always very happy to be putting this on. I know the landlord community, the income housing persons out there so desperately need for have this understanding of what's going on with the laws and how our politicians are trying to rough us up at every single stage of the game. We do have some ground rules, and the ground rules are: please leave yourself muted unless I call on you. If I don't call on you, then you're going to just have to wait. Generally, I do get to talk to everybody during this 1 hour Zoom meeting. Also, as you probably know, the information given during these Zoom meetings are for informational purposes only. If you really seek legal help, then you need to see an attorney for true legal advice. Though I do have a smattering of experience, having done this now for 47 years. But, and again, you could be doing it as long as I'm doing it. I do enjoy what I do. And I do think this community of housing providers needs so much help now. We are, as I've said in previous Zoom meetings, we are vilified by the media, vilified by politicians, vilified by tenants. And all we're trying to do is obviously make a living and provide an incredible, valuable service. I wanted to start off today for those persons who have rent control property in the city of Los Angeles. That's under the Rent Stabilization Ordinance. Our wonderful city council, after preventing landlords for almost up to 4 years from getting a rent increase, have now finally allowed a 4% rent increase come February 1st. You should be serving your rent increase notices. Again, this is only for RSO properties. You should be doing that around, I would say, December 15th. If you're going to mail it to the tenant, it's an extra 5 days. So therefore, December 15th, you'll be well within that 35-day period. If you hand it to the tenant, of course, then it's just 30 days. So we want to make it effective as of February 1st. I've been getting a lot of clients who state that, under the LA City rules, if an extra tenant moves in, I'm entitled to a 10% rent increase. So how does that impact us at this point? Well, that is true. It is part of the Rent Stabilization Ordinance that if another tenant moves in, you're entitled to a 10% rent increase. Of course, you also have the right, if it's a violation of the rental agreement, to evict the tenant, which we have been doing many of those types of evictions lately. But if you're interested in just getting a 10% increase, can you do so? And the answer is yes, you can. There is an exception that the firstborn child into the unit is exempt from that 10% rent increase, or the first child coming in. Other than that, you are allowed to raise it 10% for each additional adult. So let's pretend during this moratorium that ended in February that you wanted to get that 10%, but you were prevented from doing that, and you're only allowed to do it as of February 1st of 2024. So if the tenant did bring in 2 extra people, then under the city rules as they exist right now, you would be entitled to a 20% rent increase plus the 4%. So you could serve technically a 30-day notice, which I'm recommend do it by December 15th, that on February 1st, 2024, your rent's going to go up 24%. That's kind of a hefty rent increase, and one we certainly deserve because we haven't had a rent increase since March of 2020. That's insanity, ladies and gentlemen, when you consider the rate of inflation and how costs have gone up above the board for all service people, for our food, for electricity, our gasoline. So to not allow a rent increase for that amount of time is truly an abomination by our City Council of Los Angeles. Okay, that's my sermon for the day, ladies and gentlemen. We're going to start picking on people. Remember, always keep yourself muted unless I call on you. Please try not to have any background noise because it does kind of mess up our meeting here. I'm going to open it up right now to a nice person by the name of Ryan Fitzgerald. I'm going to ask you to unmute and say hello, sir. Oops, got to unmute. I don't think I can hear you. Are you there? Well, I'm hoping it's not just you. I guess you can hear me, but I cannot hear you. And I have asked you to unmute yourself. Are you sure you're unmuted, Mr. Fitzgerald? Okay, I think what we're going to need to do is I'm going to just, hopefully it's not on my end because I can't hear you. So I'm going to move on and let's see if we can get somebody else. And hopefully it's not on my side that is doing this. I'm going to ask Dina to unmute yourself. And if you could say hello.
Yeah, hi, Dennis. I would start by thanking you so much and much appreciation for what you're doing. I have quickly two questions. My tenant, one of them, he just started to bought a property back in August, and he just gave me this week a 30-day notice of intent to vacate the premises. So I reply back and I said, I'm in receipt of that and I will be coming to the property. It's going to be on the 16th of December at 12 p.m. to receive the property, the premises, and with its keys from you. And we are trying to, me and my real estate agent, to put it as soon as possible on the market. But sometimes we don't know because the holidays are coming. Starting the 16th is going to be but we're going to do our best. But in case that the tenant would default on paying the rent till the end of the lease, because the lease would end on the 31st of July of next year, 2024. So what action could we do? I mean, he is aware. I told him that this is per the lease, per the law, and he's aware of that. But just in case if he defaults, what?
Okay, well, first of all, when the tenant leaves, you have 21 days to send him a security deposit itemization.
Yes.
And on that form, it will, of course, deduct for cleaning, unusual wear and tear, and all rent owed. And I would add in all rent to the end of the lease term. I would also make another statement on that security deposit itemization form, which, by the way, there's one on my website at evict123.com.
Oh, great. That's good.
And on that, I would note that I will use my best efforts to try to relet the premises as your agent to minimize your losses. But to the extent that the premises are not released, then you are going to be responsible. So hopefully once he vacates, he'll continue to pay the rent until such time as you find another applicant. By the way, you can't go up on the rent. You have to try to rent the unit out at the same rate as what he was paying, because otherwise, if you try to get more rent, then that's going to be considered a waiver for the remaining portion of his lease.
So what does that mean? I mean, because my understanding, we can go by the market rate, and my property is exempt, by the way. So this is something new to me.
Right. Well, again, it's really not something new. You're trying to hold this tenant responsible till the end of his lease term. But if you're going to do that, you have to use your best efforts to lease the property to another to cut down his losses.
Yes.
But if his rent is only $1,000 and now you're trying to lease it for $2,000, the law is going to say you're not using your best efforts. So please feel free to rent it for $2,000, but you can't hold that vacated tenant responsible.
So if I want to put it by the market rate, and then at the end I will cut from whatever his rent, would that be any other way to do it? Because I want to also because of what the laws are coming, I want to put it at market rate, you know?
Well, then I think you can't have your cake and eat it too, as that expression goes. So take your poison. Probably it's best. I mean, I think you're going to figure that you're going to be able to rent the premises out in a month or two. Vacancy factor is very low. So on that basis, I would just try to rent it for the highest price, see if he still continues to pay the rent. But technically, if he's got some sharp attorney on his side, he can say, hey, I'm not responsible because you're not using your best efforts and you're putting it up for a higher amount. I am going to move on to another caller.
Oh,
Please
okay.
mute yourself if you'd be so
Thank
kind.
you. Yeah, sure. Thanks.
And I see there's a Tammy Lease. I'm going to ask you to unmute yourself if you'll be so kind. Tammy Lee. Ms. Tammy Lee, step forward. I don't know if you're calling in from a cell phone. If you are, then you can press, I think it's *6 to unmute yourself. I see that Ryan is trying to give me a thing. Let me see. Maybe I can do it this way. Let's try one more time, guys. Maybe there's something I'm not doing right here. Yeah, let's see here. Okay, I think I got it now, guys. Okay, I think I got it. Okay. Let's continue on with Tammy. Are you there? Can you talk now? Otherwise, I'll move on to Ryan, back to Ryan.
Yes.
Oh, hi.
Hi.
Okay,
Hi,
sorry
Mr.
about
Block.
that. I had a little bit of a technical issue on my side. So Ryan, I'll get to you next. And Ms.
No.
Tammy Lee, you're
Yes.
first. How can I help
hear
you?
me? Can you hear me?
I hear you wonderfully. Go ahead, darling.
Thank you. Thank you, Mr. Block, for give us the time to talk with you about our issue. My rental property is in Long Beach. It is the unincorporated.
I'm sorry, I missed that last word. It's in Long Beach, and what is it?
It is the unincorporated city.
Oh, so you're not really in the city of Long Beach. You're in an unincorporated area of LA County. Is that correct?
I don't understand what is unincorporated.
Okay, well, either you're in the city of Long Beach, and you would know that if you ever see the Long Beach police drive by your building, then you know you're in the city of Long Beach. There are
Yes.
areas in LA County that are what they call unincorporated, which means that there is no incorporated city which has jurisdiction. Usually that's places like East LA, and there's also parts of Whittier. I'm not familiar with parts of Long Beach that are unincorporated, but obviously all these places are located in the county of Los Angeles. We're not arguing that, but there are certain locations that are not covered by any city. And if you're not covered by any city, then you're considered to be an unincorporated area of the county of Los Angeles. Now, what's the significance? Well, the significance is the county of Los Angeles has their own rent control statute. They do require you to register your units yearly, and they have eviction controls, and they have meager rent increases. So it's not a friendly place to be for those areas of an unincorporated area of LA County. Hopefully that answered your question.
So when I send the 3-day notice to the tenant, do I need to send that notice to the city?
Okay. If your property is in the city of Long Beach, the answer is no. There is no
Right.
requirement. If your property is in an unincorporated area of LA County, then you are going to need to send it to the county supervisors. I have that actually on my website. I have a list of all the addresses. If you go to the free forms section and look where the 3-day notice is, and there's another link to show you the addresses for the county, and there's a bunch of cities that you have to send it in to, including Culver City. You'd have to send that in the city of Santa Monica, West Hollywood, There's all these municipalities that require that. I think even Cudahy. So you need to take a look at that, and it's right on my website.
Yes,
Thank-
I saw. I watched the video last week and I saw the list, but I'm confused about the unincorporated. Yes. I see the city of Long Beach police department drive by.
Okay, so
And-
then that means, darling, you are not in unincorporated area of LA County. You are in LA County, but you're in the city of Long Beach, so nothing to worry about. Service standard 3-day notice. I'm going to move on to that poor
Thank you.
gentleman. Thank you. Ask you
Thank
to mute yourself, Tammy. I am now going back to Ryan. That was a technical problem on my part, and if you could unmute yourself, I'd appreciate that.
Sure, can you hear me?
I can.
Okay, great. Thank you so much. What are the best ways to open an escrow account if you have to pay a tenant for relocation? And what are the pitfalls of that the city is going to look at if I don't do it correctly?
I normally don't suggest to my clients to open up an escrow account. Usually, and what we're talking about, ladies and gentlemen, is that, for example, if in the city of Los Angeles, if you wanted a tenant to move because you wanted to put a family member in, you would have to pay relocation. That relocation can it's supposed to either be given to the tenant within 15 days of the service of the 60-day notice, or you can put it in an escrow within the 15 days. The city has their instructions for opening up an escrow, which you can open up with any escrow company, and just give those instructions that are printed on the city's website to your escrow company. I just think it's easier, quite frankly. It just opens us up for more defenses when we start the lawsuit if our little friend doesn't move at the end of the 60-day period. So I think it's just best to give them the money within the 15 days. I understand the nature that you're afraid that the tenant might not move at the end of the 60-day period. But from my standpoint, if the tenant takes the money and doesn't move, that's a pretty simple case to evict that tenant. Okay.
But then I'm out the money though.
What's that?
But then I'm out the money.
Well, yeah, well, you're going to be out the money whether the tenant gets evicted or the tenant leaves at the end of the 60-day period. You don't get the money back ever. That money is the tenant's, even if he didn't comply by doing it, by moving when he was supposed to move.
But let's say like you do this and the tenant then doesn't pay, because they still have to pay rent during this 60 days. What if they don't pay rent? How does that?
Then you could start a case based on non-payment of rent at that point.
But then if I were, let's say I were to serve them 3 days that they didn't pay and then they paid, then I have to start all over with the 60 days, correct?
No, the 60 days is still running. So if in the first month you served the 60-day notice and you gave them the relocation money, or you put it into an escrow, if they don't pay the rent, you can serve a 3-day notice and proceed forward with an eviction. However, the way the ridiculous ordinance is written, they're still entitled to the relocation, even if they didn't pay the rent, because you've already filed that declaration with the city, which is required to do prior to serving a 60-day notice. You have to go through an application process with the city. And if once it's approved, you're on the hook to pay that tenant.
See, that's the thing, is that the city tells you something completely opposite of that.
No, that is exactly what the ordinance states. You have a lot of people who are employed by the city who I don't think ever read their ordinance.
Right.
In any event, Ryan, I'm going to move on, but thank you very much. I'm going to now call on a person by the name of Michael. Yeah, I'll ask you to unmute yourself.
Hi, Dennis. How are you? Can you hear me?
I do.
Thank you. This is a similar question. So we're looking to purchase a single-family house in unincorporated Los Angeles. There are currently tenants in the house. They say they're open to a buyout. We have stated we'll contribute funds to the buyout, but we expect the house to be delivered vacant. If the so we expect the tenant buyout agreement to be between the seller and the tenants. If they don't do it correctly, but deliver the house vacant and we purchase and move in, could we have any type of liability there?
The answer is no. They're not your tenants. They've never been your tenants. You're just a bona fide purchaser walking into an empty unit. So if they don't comply correctly, they're the only ones who have any responsibility whatsoever. You have no contractual basis with these tenants.
Okay. If we were to take on the laboring oar of doing a tenant buyout, well, first of all, if it's a single family home in unincorporated Los Angeles, you can raise the rent to any amount and do that eviction process, or do you have to do a owner occupied no fault, or is it just like different ways to do it?
Okay, so anywhere in the state of California for a single family home, a townhouse, or a condominium, you have the right to raise the rent to market level.
Okay.
If you're going to go above 10%, then you need to serve a 90-day notice. If you're going to do 10% or less, then you're going to serve a 30-day notice. But there is no law as it stands right now that would prevent you from raising rents. There is going to be something on the ballot come November of 2024. It's the third time they have tried to institute this new ordinance, which would basically do away with your right to raise rents to market level on condos, single family homes, and townhouses. But it would do one more thing if this law passes. It would allow municipalities to state incredulously that when you have a vacant unit, the tenant voluntarily left, now the city could take away your right to raise the rent to market value. This is beyond insane, and it's coming up on the ballot come November 2024. Please tell all your friends to vote against it.
Got it. Thank you.
All right, we are going to move on, and I'm moving on too. So if you could please mute yourself as soon as you're finished with me. But right now I'm going to ask Hovik to unmute himself. Okay.
Hello, Mr. Dennis Block.
Hello, sir. How are you?
Great, thank you. Thank you for your continued support here. I have a lease agreements to all my tenants, and in the lease agreement, in the notices section, I include where they can contact me. So including my phone number, email address, and a PO box. I remember from last week's Zoom, you mentioned that PO boxes are okay for payments, but they're not okay for notices. How would you suggest I can, keep my residence private? I don't want my tenants to know where I live. One reason is because I've had a tenant threaten me before, and I really don't want to know where I live, of course. So wanted to know if you can offer some advice.
I certainly can. Do you have a brother that you don't like?
I do not.
Oh, that's too bad, because that would be the address I would be giving. I actually have a brother that I don't like. So no, I'm just kidding. I don't even have a brother. You have to have, it's under California law. And by not having a physical address, they could actually defeat an unlawful detainer. I would send an amended change of ownership notice to them, and you've got to give an address. So you can appoint an agent, but it's got to be a person that they can walk up to and hand them legal process, like when they want to sue you.
Can it be a real estate brokerage office?
Well, it could be a real estate broker in an office. Yes, that would be fine.
Okay. And then one last question, if I may, it's really quick. Am I allowed to unbundle the parking from the rental unit in the contract and then charge them additional for the parking space?
What city, please?
Glendale.
How many units?
I have one that's 7 units and one that's 9.
Okay, so they're both under the Glendale statute, and the answer is no. You can do that for new tenants moving in, where you have a separate parking agreement, and from the rental agreement. So you have a rental agreement and a parking agreement. I have actually a rental agreement and a parking agreement on my website. You can do that separately. Now, why would you want to do that separately? People might be thinking. And the answer to that is that Glendale has rent control. In fact, every city has rent control for residential units, but a parking space or a parking garage is considered commercial and there are no limitations. So if they're on a month-to-month parking agreement, you'd be able to give them a 30-day notice to get rid of the parking, or you can go up on the parking $100, whatever you want for that parking space. So it gives landlords with under rent control a more power to control their fate for that unit, because you can control the parking spot, and that might be enough impetus to have the tenant vacate if that's what you're looking for, or at least to get more revenue above what the rent control statute would give you.
So just to be clear, this is only okay for new tenants coming in.
Absolutely, only for new tenants coming in.
Thank
We
you.
are gonna move along here as I go down this list. And let's take Maria, I think that's Lacobo. I'm gonna ask you to unmute. Are you there, young lady?
Hi, can you hear me?
I hear you wonderfully.
Great, thank you. And I just want to echo everyone else's thoughts and thanking you for sharing your expertise with us this way. So I own one duplex in the city of Los Angeles. It's under rent control. And when I provide my tenants with the rental increase notice, I'm wondering if I can provide them with a new lease using your lease off of your website, or if it has to be the rental increase notice. And if I can ask them to, if I can require them to sign it back within 1 month. So if I gave it to them on December 1st, could I ask them for it back on January 1st?
Well, first, I'm going to assume that the duplex was built prior to 1979, correct?
Yes, it's definitely under rent control. Yes.
Okay, so, and currently the tenant is on a month-to-month.
Both tenants are on a month-to-month. And this past year, I did not bother giving them a notice that's saying, you know, your rent is the same, because there was no point in it.
Exactly, because you'd have to tell them their rent is not the same, then there's a point to it. But
Right.
if it's going to remain the same, you can send your tenant a lease and say, please sign it and have it back to me in 1 week. But the reality is there is no obligation on the part of the tenant to sign a new rental agreement, and generally they're not going to do it. So you just need to do the rent increase, which is 4% come February 1st, 2024. I didn't mention, though, that, and I'm sure this is not your case, but if the landlord does supply the electricity for the unit and supplies the natural gas for the unit, then you're entitled to an additional 1% for each of those utilities charged. I said nothing about water intentionally. It's only natural gas and electricity. So you would, instead of a 4% rent increase, that would be a 6%.
May I ask you one more question?
Of course.
Okay, thank you for that. So I'm trying to sell my building now. And
Good
back in
reason,
August-
too.
Yeah, well, I had to leave Los Angeles in 2018 to help my parents out on the East Coast. When I tried to move back in 2021, the city wouldn't let me. And finally, by the end of last year, before they made their notice, I finally just got disgusted with the whole process and I bought something here. So I've decided I'm not coming back to Los Angeles. So I'm trying to sell my place. And the difficulty is both units are rented, and both units are, I mean, they're not market rate. They're lower than that, but that's okay. I mean, I've kept them low when I was living there because I wanted to, you know, and I wanted to enjoy my property while having, you know, somebody else paying rent and being but not being difficult. Regardless, that's fine. So now, though, I have tried to get rid of one of the tenants and I offered them $15,000 last August if they would to move, to make it easier for me to sell the duplex, and they turned that down. I am thinking in a few months of offering them a little bit more money. And I'm wondering how stern I can be in the request.
Well, this is called a voluntary vacate agreement, emphasis on the word voluntary, so both parties have to agree. I am sure if you offered your tenants enough money, they'd move. 1 million, oh yeah, I'd be out tonight. So, but the issue is you can continue to offer more money and they can continue to say no. One, you're selling, so it's a little different. Normally, when I'm talking about voluntary vacate agreements, and let's pretend that the tenant's paying 1,000 and you could get 2,500 for it. So that would be an additional $1,500 per month. Well, how much is that worth in terms of getting them out? I would surmise that if you offered a tenant $40,000 to get out, most people would think, gee, that's really high. I think that's really low, because for $40,000, where can you get a return on your investment where you put $40,000 in a bank and you get $1,500 a month more for the rest of your life? So, and the same thing is going to be true in your example, is if the duplex is, and let's just use numbers off the top of my head, is worth $1 million. And you know that if it was vacant, it would be worth $1.3 million. If those are the numbers, then you tell me, would it make sense to offer them $50,000 each? Well, you know what? You're selling it anyway. You know yourself that you can get an extra $300,000 if you get rid of these people, because that's what the market's going to bear. So wouldn't that make sense to offer them $50,000 each? You're still going to be another $250,000 more. So I think those, and this is more of a lecture on accounting and economics as opposed to a legal discussion. But I think it does make sense that you have this valuable asset, and I think it's time to see what you can do to step up to the plate. Now, the tenants aren't stupid, okay? You know, they might get $40,000, but then they know themselves they're going to have to pay another $1,500 a month. They're going to need like a $2,500 place as a substitute place for what they left. So you're going to get a lot of pushback anyway. But I know I did and I've mentioned this in other things, that in other Zoom meetings, that I had a duplex, which it's family owned, and we still have it. It's Melrose and La Cienega. Very nice neighborhood, a very nice duplex. I finally came to terms with this person, $37,000. This is the great Dennis Block. I gave my tenant $37,000. His rent was $995. And I put in $400,000 because the other unit was vacant at the same time. I put in $400,000. I renovated. I gave him a new garage, everything. We got him in there. Each unit is paying me $5,500 a month. So that was the best $37,000 I've ever spent. And now we have a valuable asset. So anyway, nice chatting with you. I'm going to move on. You know what? This particular person I'm going to call on has probably the best name on the planet, because his name is Dennis. So I'm going to ask you to unmute yourself, Mr. Dennis, and if everybody else could mute themselves. Dennis, how are you?
I am doing very, very well, thank you. And
no, wait a second. I remember. Is it a trombone? What is it that you play?
A trombone.
There you go. See, I got a good memory. One day you'll have to give us a little musical interlude. Oh, here we go, ladies.
I can't spell. How's that?
The Saints come marching in.
What you wanted.
Thank you so much.
You're welcome.
Well, you got to admit this is amusing, ladies and gentlemen. And what is your question, Dennis, to Dennis?
Okay, here's a scenario. Tenant owes right now $2,680. I have wanted to get that tenant out anyway. I'm not going to get the money. I know I'm not going to get the money. I entered into an agreement with the tenant that on the 30th of November, she is supposed to vacate no later than 30th November. I even said, when she gets her U-Haul, I'd give her $500. When she gives me the keys, I'll give her another $500, and I will give her whole deposit back. Now, I expect that she is not going to be out on the 1st. Is that actionable?
Well, did she, number one, sign an agreement to be out?
It's all right here. Got 3 signatures.
What city are we talking about?
The wonderful city of Riverside, Moreno Valley, in the wonderful county of Riverside County.
Okay, so that's different than Los Angeles, because Los Angeles, I'd be telling you a bad story,
I know you
but
would.
that's civilized place to own property. If she's not out on the day she said she's going to be out, an unlawful detainer action could be filed.
So is this document actionable? That
As long I'm not going to read the document, but as long as it says that the parties agree that the tenant will move on such and such date, that's all I need. She signs it, you signed it, there was consideration for it, so we're good to go. What happened to you? I lost you. I don't think I did anything.
And also, let's say she stays on the 1st, all bets are off. She doesn't get the $500. She doesn't get the $1,000.
No, but we still get to evict.
And now, are you going to do?
Then I'd want to look at the contract to be sure exactly which way, whether you should give her the money or not. But in any event, you have the right to proceed forward with an eviction.
And by the way, just question mark on that kind of eviction. Are we looking at 45 days, 60 days, 70 days, 80 days, 100 days?
For that area, LA is a whole different story because the sheriff's office are taking a month and a half to do a lockout. In that area, you're probably looking at about 6 to 8 weeks.
Oh, okay, super good.
All right, young sir, keep that name, keep that music flowing. I'm going to move on. Please mute yourself. I'm going to move on to Leslie Hope. If you'd lower your hand and unmute.
Lower my hand.
There you go. You're there.
Okay, so I have a couple of questions from last week that I just watched. You said that you can, I have some older tenants under RSO that I've had for a long time, when requiring renter's insurance was not a thing. And you said that you can just serve a change of terms of tenancy to require renter's insurance.
Yeah.
My understanding under RSO is that they don't have to accept that. So, and sign it. And I'm pretty sure that,
no one ever signs a change of terms of tenancy. Okay. Just like when you do a change of terms of tenancy for a rent increase, that doesn't have a signature because quite frankly, no tenant would sign it. So you'd never get your rent increase. The change of terms of tenancy is valid, rent control, non-rent control, to request them to have renter's insurance. Now, you cannot use that to evict them, but that's not why you're doing it. You're doing it because if, God forbid, there is a flood in the unit through no fault of the tenant and all of their wonderful treasures have been ruined, they're going to look to you or your insurance company for a payment. But if you read the way I wrote that change of terms on my website, again, evict123.com, by serving that, you're going to make sure that you're not responsible. So if they try to sue you, you can point to the fact that pursuant to the terms of the rental agreement, you were supposed to carry renter's insurance for both not only your personal property, but also for any relocation money if you had to vacate the unit for a short period of time. And you can't seek damages from me because contractually you are responsible and should have been compensated by your insurance company.
okay. And then let's see, the other question, I think you answered it, but I just want to clarify. I've got two more, another question. Email, you said email is okay for a tenant to request a repair in writing. Is a text okay?
I would think a text is okay. I mean, it's basically whatever the landlord wants. You can say it has to be put in writing and emailed to me, or it has to be mailed to me. Obviously, if it's a repair request that is of an urgent matter, then you don't need anything. Hey, there's a flood coming. I'm not going to send you an email or a text. Get your butt over here and fix this damn thing. But otherwise, yeah, I don't have a problem with the tenants texting. What we want is we want to have proof. That's what we're looking for. We want to have proof that it was done. Now, we all know that our texts can be saved. You can upload them both on iPhones and on Androids. And you can just save that as a permanent record to prove that, in fact, when he requested it, or if he didn't request it. It's as simple as that.
Okay, and just my last question. I have, this is in one of my RSO units. I have a tenant that she's moved in, you know, one child. It's a relative that she's been caring for years. And now she's, during COVID, she's moved in another child, again, a relative, a child whose mother is serving in the armed forces. And so I think I can raise the rent 10% for the second child. The first child isn't on the rental agreement at all.
But the first child came in after the rental agreement started?
Yes.
Okay. Yeah, technically, I wouldn't do this, by the way, based on the fact that this woman seems to be a saint, taking in children while their mother is in the armed forces protecting us. So I don't know how that would look. But if you're asking me legally, can you do that? My answer would be yes, 10%, and make it effective as of February 1st.
But you don't advise it. Well, I would have to give
I just think it looks good. You know, we have to be so above all kinds of levels of morality and ethics.
Mhm.
I mean, they make us out as the worst, and you could just see how this would look to, you know, somebody marching up and down your street, like, you know, look what this person did. So I'd probably avoid that.
Let it go.
But just,
Yeah.
okay, look at that. Okay, we're going to submit that. Well, that was my first one, guys. We got through like about 6-7 weeks without an asshole joining us, but that's good. I hope he enjoyed himself. Anyway, I think we are going to move on. Thank you, Leslie. If you'd mute yourself, I'd appreciate that. We are going to move on to Max. Max, are you there?
Hi, Mr. Block.
Hello.
Quick question. There is a person in one of my units that I believe is the tenant's son. I'm not sure how old they are. They look to be around 18. How do I go about figuring out what their exact age are, because they're not on the rental agreement? And if they're over 18, serving them a 10% increase.
That's interesting. Yeah, if an adult child moves in, then you could do that rent increase. So, well, you can ask. You can ask them. How long has he been in the unit?
At least a couple years. But does that violate, like, I feel like does that violate a law asking age? Is that one of the?
Well, I'll tell you, you know, if you think the child is 18, then why don't you serve the rent increase notice? And if they want to, you can put it on the notice saying this notice is valid if you're 18. If you want to show me proof that you're not 18, I'll retract the notice. How about that? That's a good way to do it.
Does the 60 days to serve an increase after you're made aware that someone else is in the unit, is that overwritten by we have not been able to charge for extra tenants in the last 3 or 4 years?
No, because if you're talking about that you had to do this rent increase within 60 days, if that's what your question is, then you weren't allowed to raise the rent under any circumstances. You weren't allowed to even evict for unauthorized persons moving in, using your electricity, using your services. You weren't even allowed to evict for that. So right now you're within 160. Yeah, I think you got 60 days from February 1st to do it, because that's the first day you could raise the rent. So we're going to do it around December 15th. Now, I haven't, there's been obviously no court decisions on this, and RSO hasn't issued any proclamations on this. So I'm just going with my gut, what I think is reasonable. It's in their statute, so I don't see why we can't do this. So I would certainly do it and put a note on the bottom. Hey, you know, if you're not 18, then this rent increase. But actually, the issue would be, as I start to think about this, he moved in a couple of years ago.
Mhm.
Well, then a couple of years ago, he wasn't 18.
I'm not sure how old he is. I've
Okay,
never
so
asked.
the issue is, was he 18 when he moved in? That's the issue. Because if he wasn't 18, he was lower, he was 17 or 16, which now seems more probable, then you wouldn't have been able to do a 10% rent increase because it's the first child moving in. So I think you're out of luck.
All right, so no rent increase.
So I don't think you can do a rent increase, because I think 2 years ago, you tell me, do you think it's more likely that he was under 18 2 years ago? That would make him 20 now.
Not entirely sure, but I
Okay,
guess
but the purpose of these meetings is to educate you on the law. Now you got to deal with your own facts, my friend. At least
Got
you
it.
know. Anyway, thank you very much, Max. And we're going to move on to Carolyn. I'm going to ask you to unmute yourself. And Max, if you could mute yourself, thank you.
Hi, thank you. Can you hear me?
I can.
I need to double check on something you said like maybe a week ago or so. So if a tenant that's fell into the COVID, moratorium time period, and she stopped paying, like say August 2021 in the first set, and then say is it January? Was it January the last of the moratorium, and then you get a year? Like if she started paying rent again? So
I can answer that. There's
That's-
2 time periods. We're talking the city of Los Angeles, correct?
I understand the time periods, but what I'm saying, she fell in the first one, say, and I think the last moratorium, well, you can correct me, but the January, it's January 2023, but does that mean, she start paying again, but she can be evicted for past rent, but that would mean I would have to evict her by January 24?
Okay, so let's go over the dates, because everybody has to understand this. We're talking about the city of Los Angeles, any residential unit where people weren't paying during the pandemic. So the city of Los Angeles stated that any rent owed from March 2020 through September 2021 is due right now. It was actually due in August. So we could serve, it's a 15-day notice to pay rent or quit, but we could do that and then proceed forward with an eviction for any rent owed from March 2020 through September 2021. Now, any rent owed from October 2021 through January 2023 is not due until February 1st. On February 2nd, we could serve a 15-day notice to pay rent or quit for any rent owed during that time period. And if the tenant doesn't pay it, then we have the right to evict.
Right, but so say she fell in the first one, that means the end of the moratorium for that, or was
That first one, we could start an eviction right now, or you could sue her in small claims court.
But then you get a year from the date of that August 2023, you get a year from that.
Okay,
Not
you're talking about the second period or the first period, darling?
first period.
Well,
So-
the first period's due right now. You can sue her, you can have me evict her.
But what I'm saying is, how I think you mentioned you get a year to evict, right? So that means from August of 2020.
I think I'm saying, I think I know what you're saying. You're saying you can't bring an eviction action for rent more than 1 year old. Is that what you're what you're talking about?
Is that from
But it's from when the rent became due. So even though the period, let's take that period again, from March of 2020 through September of 2021. Now that's more than a year's old worth of rent. So under old rules, you could not bring forth an eviction because that rent was more than 1 year old. However, that rent didn't become due until August 1st, 2023, like a couple of months ago. So on that basis, it's not more than 1 year old. It only became due. So you'd have until July 31st of 2024 to bring forth an eviction for that period of time.
That's how confusing that is. Thank you. And then I had one more little thing.
One last, because I'm trying to get through everybody today.
If someone's already evicted, can they come back and sue for like, inhabitable, whatever,
Anybody can sue anybody for any reason, including me suing you because you jumped onto this meeting. That doesn't mean I'm going to win, but anybody can sue anybody. Okay. Normally, when they file these habitability lawsuits against landlords, which my firm does handle in conjunction with my son's firm, which is called Block LLP, they generally do that while the tenant's in possession. They don't usually do it afterwards because then they can't take pictures of all the crazy things. All right, I'm going to move on. If you please mute yourself. I'm going to now ask for Carolyn Falk. If you would, I'm going to ask you to unmute. And if you're there, Carolyn, say hello. Hello, Carolyn. Carolyn. Oh, you're Carolyn.
Was me.
Oh, okay. Oh, you mute yourself. I got to move on. I have a number here. It starts 1415. I'm going to ask you to unmute where it says 1415. If you can unmute yourself. If you're on a cell phone.
Good.
Oh, good. You got it.
Good afternoon, Mr. Block. You know, a lot of attorneys have the personality of a cactus, whereas you have some entertainment value. I really enjoy listening.
Thank you.
My question relates to SB 602, which puts law enforcement on notice that no one has the permission to occupy the premises and allows them to arrest squatters. I was able to see some examples of letters of agency, 602 letters. There's various terms for them. And those were in Southern California. I know it's out of your neck of the woods, but I'm in Northern California. And so I called local agencies, Berkeley Police, San Francisco Police, Alameda County Sheriff, etc. And they have absolutely no idea what I'm talking about. But clearly it's a state law, so it applies throughout California. So I'm wondering, is there a standardized form, or is this something that we could just improvise and model letters after, let's say, Palmdale and other locales?
Yeah, I'm not exactly sure what you're talking about, but I have a pretty good guess. When you file an eviction lawsuit, there's something called a prejudgment claimant, where somebody can, only in California, ladies and gentlemen, can somebody force themselves to be a defendant. Like, who in life wants to be a defendant in a lawsuit? It's insanity. So, but in California, you can force yourself into an unlawful detainer and become a defendant on the basis that you have a possessory right in the premises. So there is a procedure when you file an unlawful detainer where you can serve all unnamed tenants. And if they don't respond, you can take what they call a default against them. So at the end of the case, when you get the final, it's called a writ of possession. That's the court order that you deliver over to the sheriff's office. There's two boxes on the back of that writ. One says, hey, this writ's good against anybody. And then there's another box that says, this is only against the people that you sued. And if somebody wants to file a claim, which they could, that would stop the lockout. And you'd have to go back into a quick court hearing to determine whether that person is a proper person in possession. So the sheriff's office, and this just happened to me this week because I was not aware of this, We had, of course, served our lawsuit in accordance with getting this, what they call prejudgment protection, where the writ's good against everybody and the box was clearly checked. And we had a place, I think that was in, it's either in San Bernardino or Orange County. And the sheriff said they weren't going to do the lockout, and they sent it back for the court to set up a hearing, which is coming up this week. So it's coming up quick. And we called the sheriff's office and we said, wait a second, my writ has protection. You should have done the lockout. And they said, no, there's this new California law, which is what I think you're talking about, that states that we can't make that decision, which makes no sense because you're not making the decision. The court order says throw out everybody, but they kicked it back to the court. So I think that's what this law is. I wasn't even aware of it until I think it was Friday or Thursday of this week. But it is just one more abuse on landlords, where now you have to be concerned with strangers claiming that they live there. Okay, let's make sure we have the protection when we file the lawsuit to prevent strangers from raising these claims. But now, even if you have the protection, it still has to be determined by an officer of the court. It makes no sense. Anyway, that's the best answer I got, and thank you for coming on. I'm going to now move over to Juan, and I'm going to ask you, Juan, to unmute yourself, if you'd be so kind.
Can you hear me?
Yes. Is this Juan?
Yes.
Hello, Juan.
Mr. Dennis Block. Quick questions. I have two simple ones. I have a tenant whose plumbing got clogged. I called the plumber. He went out there, ran one of those uncloggers through the line and broke the clay pipe on the main line. And the tenant, he told me that his grandkids threw some toilet rolls through there. So it broke because of that. Are they liable for that repair?
If a tenant puts something unnatural down a drain, then the tenant is responsible. Okay, you put a baseball bat, you put a toy down the drain, that's going to be on the tenant's dime. So they're the ones responsible.
And how could I collect on that?
Well, you'd have to sue them in small claims court. It also might be grounds to evict. If you, based on the way your rental agreement is written, you could serve them, send them a copy of the invoice, say, this is your responsibility. You've admitted that your kids did put toilet rolls down the drain, which created this problem, and give them 7 days to pay it. If they don't, then we could serve on them a 3-day notice to perform or quit, giving them 3 days to pay that invoice. And if they don't, we could proceed forward with an eviction. Juan, what's your other question?
The other one is, I have tenants that are been in their units for a few years, and they're asking for, say, cabinets, countertops, because they're outdated, but they're still in good condition. If I change them, are they allowed to pay for these things or not?
What city, please?
It's LA County. It is under rent control.
Unincorporated LA County?
It's LAPD. So
okay, so when it's Los Angeles City, you can make a side deal, even under rent control, with a tenant that we're going to put these cabinets in and you're going to pay me for these cabinets. You're not charging them on like a rent for it. It's got to be a payment, or I guess you could put it on payments, but just do a separate contract. Say, we're putting in these cabinets and nothing was wrong with them. You've asked us to make some cosmetic changes. We will do it. The cabinets are going to cost $1,500. Give me $1,500, or you could say pay it at $100 a month. Now, if they didn't pay it, you wouldn't be able to evict them for that. You'd only be able to sue them in small claims court.
Oh, okay. Okay.
All
and
right,
then I'm sorry, it's a quick one.
Go
you
ahead.
had said that the rent increase was going to be 7%. Now it's 4%.
It was going to be 7%, and those bastards who run something called the City of Los Angeles reduced it to 4%. It's insanity. I'm going to take one more. I'll take two more calls.
Thank you.
Even though we're over the time period, please mute yourself. I'm going to talk to
Hi, can I come in?
No, nobody talks unless I ask them. That's our rules. Okay. Otherwise you get banned, my love. So we're going to go to Kaio. I'm going to ask you to unmute yourself. Takai?
Hi, can you hear me?
Hey, how are you?
Thank you. How are you? Thank you for
I
doing
can't
this.
complain.
Okay, I will make it quick. I have a tenant who's been living here for 5 years. He signed a renewed the lease, and now it's another new 12 months lease term. He owes me money for Edison power bill because we had a construction and I have to use a temporary pole service from an Edison company. For that, I was covering his share. He and I agreed to the amount he owed, which is $600, and he hasn't paid. Which notice should I use to
Well,
serve?
I don't know. I have to ask some other questions first. The first question would be, did he put it in writing that he was going to reimburse you for the $600?
He texted me so that I have a writing.
Okay, I think you're okay, that he agreed, because normally he would be paying for his own electricity, but because there was a problem, you only had 1 meter, and he agreed that his share on that in writing would be that. It does state in his rental agreement generically that he has to pay for the utilities. So I would
Yeah.
serve a notice to perform or quit.
Perform or quit?
Yep.
Okay.
And giving him, the 3 days to pay it. And if he doesn't, I think we could go forward with an eviction. I'm going to ask you to mute yourself if you'd be so kind.
Thank
And now
you.
we're going to take our last call of the day, which is going to be Jade. I'm going to ask you to unmute yourself, please. Hello, Jade.
Yes,
Hello, Jade.
thank you
How
for
are
taking
you?
my call. And
Yes.
I purchased a house about 10 years ago, and it comes with a studio next to the garage. And the studio has a small shower area and also a small kitchen. Recently, the LA County found out, and they asked me to, it has an order to perform and asked me to evict the
Is there
tenant.
somebody living there in that studio?
Yes.
No,
Yes.
that's a problem. And this is in the city of Los Angeles?
This is a county unincorporated area.
Okay, well, they have a similar rule to the city that you're gonna have to go
Yes.
through a process with the
Yes.
county, and then you're gonna have to pay relocation. I don't have it off the
Yes.
top of my head, but I'm gonna guess it's
Yes.
about $18,000.
Yes, it's a studio. I paid about $11,000. He is moved out, and then he sued me for habitation thing, and
But
also
how long did you own the property for?
10 years. He lived there 8 years.
Okay, well, is this a small claims court lawsuit or a regular civil lawsuit?
Yeah, civil lawsuit. He asked for a lot of
Okay.
money.
All
So,
right, so
I'm
what you
asking,
can do is 2 things. Number 1, you should call my office, but the second call should be to your insurance company to see if they'll pick up representation. We can also assist with that, so I would certainly call my office.
Yeah, okay. Thank you so much. And you think judge will award his back rent, or should not?
I don't think so. Those cases generally don't go anywhere because he did get value for even if it wasn't a permitted unit. So I think you're okay, and we have handled that issues. I want to thank everybody.
Thank you.
This has been kind of a lively session. Sorry for what would that be? Oh yes, I know, the asshole who jumped into our telecast. But in any event, we're happy to be coming back next Saturday at 3 p.m. Keep your questions short, but I'm always attempting to answer everybody. Have a great week, everybody, and I'm signing off. Take care.
Thank you.
Thank you.
Thank you.